Hello, everybody. My name is Connor Lynch with Westwood Media Center. We are proud to be partnering with the Council on Aging to provide virtual programming through our cable channels and online to keep seniors engaged throughout the coronavirus pandemic. We can be found on Comcast channels 8 and 12, Verizon channels 32 and 42, as well as online at westwoodmediacenter.tv. I'm happy to turn things over to your host for the evening, the Director of the Council on Aging, Lena Arena DeRosa. Lena, take it away.
Hi, everyone. Once again, thank you, Connor. Thank you, Westwood Media Center. We couldn't do this without your partnership, and we are so grateful. So thank you. Hello, all my seniors. It's so great to see you again. Of course, I'm not actually seeing you, but you're seeing me. And we're grateful that you've tuned in today. Today, we have Maria Baler. I'm going to read this so I say it correctly. Attorney Maria Baler. She is a partner at the law firm of Samuel, Sayward, and Baler, LCC in Dedham, Mass., where she concentrates her practice in areas of estate planning, probate, trust administration, and of course, elder law. Attorney Baler is a former member of the Board of Directors of Massachusetts chapter of the National Academy of Elder Attorneys. She is currently the president-elect of the Massachusetts Forum of Estate Planning Attorneys. Attorney Baler received her undergraduate degree from Franklin and Marshall College and her JD degree, cum laude, from Suffolk University Law School. She and other attorneys in her firm contribute a newspaper column on estate planning and elder law issues to the Dedham Transcript. She speaks frequently on these topics to local community groups, and I've had the pleasure of her being a regular here at the Westwood Council on Aging, and we have become friends. So thank you, Maria, for joining us. Oh, one other thing, she's married and has a lovely son. I had to say that. And her mother-in-law lives at the Glens. So it's all very fun. Maria, it's been such a pleasure working with you over these years. I'm sorry we can't have you here personally, but it's great that you were able to come to us and do a video for us. For all of you out there, this is probably one of the most important ones that we do, and you really need to understand what your legal responsibilities are. Take it away, Maria.
Thank you, Lena. Thank you, Connor. And hello, everybody. I might look familiar to some of you if you've been to any of my programs at the Westwood Council on Aging, but if you don't know me, I'm happy to be here today talking to you about documents, legal documents that everyone should have. We're calling this Don't Leave Home Without Them. So let's dive right in. The first category of documents I want to talk to you about, and I'm having some problems with my slides. Oh, there we go. Are documents that allow someone to help you if you're incapacitated. We're also going to talk about documents that that make sure your assets go where you want them to go after death. So these are the two different categories. Documents that allow someone to help you if you're incapacitated will allow them to help you make financial decisions and healthcare decisions and let people help you. And these are the documents that are important because these are the decisions that are really going to impact you while you're still with us. The second category are the documents that make sure your assets go where you want them to go, a will and a trust, for example. But let's talk about the details of each particular document and let you learn more about which ones might be appropriate for you. So the first document, one of the most important documents anyone can have is a durable power of attorney. So this is a document that names a person to make legal and financial decisions for you if you are not able to make those decisions for yourself. Typically, this document is used if you're sick and you're otherwise incapacitated and can't make those kinds of decisions for yourself. Occasionally, a power of attorney can be used by the person you name if you go on an extended vacation and you want someone to do things for you while you're away. But none of us are going on extended vacations right now. So think about this document as one that would be used if you're ill, you're in the hospital, or you're having other kinds of issues that prevent you from making sound decisions for yourself. The document is going to be very specific. It's going to authorize this person to do anything you could do regarding your financial matters. So things like, signing checks, having access to your bank accounts to withdraw funds or deposit funds, paying debts, selling real estate, filing your income taxes, applying for Medicare or Medicaid or disability benefits, if that's something that's necessary for you. And also if you provide, making gifts of your assets, which can be important for tax planning. This is a document that is prepared by an attorney, and that attorney should be having a detailed conversation with you about who you want to name and how extensive are the powers you want to give that person, based on what you would want them to do if you couldn't do things for yourself, and what's appropriate for your situation. So it's an important document, but one that takes some discussion before it's prepared. The next category of documents have to do with healthcare decision making, and this is also really important. You can be too ill to make or communicate your own healthcare decisions, and at that point, your physician will decide that someone else needs to make those decisions for you. If you have a healthcare proxy, that's a document that will appoint that person to make those healthcare decisions for you when your physician invokes your proxy. And that document will authorize them to do a variety of things related to healthcare, consent to treatment or refuse treatment on your behalf, decide where you're going to be cared for and admit you or discharge you from those facilities, authorize medication that your doctors might recommend, consent to surgery, decide who it is that's going to be treating you, which physicians you're going to be treated by. All the way to decisions about end-of-life care. The end-of-life care decisions, get a lot of attention. They're, obviously the most dramatic and difficult decisions, but a healthcare agent who you name in your healthcare proxy will make any kind of healthcare decision for you that might come up when you're not able to make those decisions for yourself. If you create a healthcare proxy, you want to give a signed copy of that document to your doctor to put into your medical record, and also to the healthcare agents you name in the document, the people who are going to make the decisions for you, so that they'll know they've been named and will have proof of that if they're ever called upon to make that kind of a decision. When you're choosing a healthcare agent, you want to choose someone who you're comfortable talking about your wishes with in terms of your healthcare, and someone you can trust to carry out those wishes if the time comes when they have to make decisions for you. A second healthcare document we sometimes prepare for people is called a living will. This is different than a healthcare proxy in that it's just an expression of your wishes. The healthcare proxy appoints the person to make healthcare decisions for you, and the living will tells your healthcare agent what your wishes are about, particularly about end-of-life care. Typically, a living will say, if I have a terminal illness and I'm, there's no hope of my recovery, and two physicians have agreed that that's the case, then I do not want any kind of care that would prolong my life artificially. I want to be allowed to die naturally and have my life not prolonged beyond its natural course. In Massachusetts, the living will is not legally binding on anybody. It's just an expression of your wishes that can help your healthcare agent in making these kinds of decisions. And you may have a conversation with your healthcare agent about what your wishes are, but they're not necessarily going to remember what you told them 10 years ago if they're under the stress of having to make a difficult decision if you're very ill. So a living will can be helpful to guide your healthcare agent, and also to, if anybody is questioning their decision, any other family member, they could show them the living will and say, look, this is what mom wanted. It's right here in writing. I'm making this decision based on her wishes and not on, just my best guess of what she would want. There's also a document called a MOLST, M-O-L-S-T. It stands for Medical Orders for Life-Sustaining Treatment. This is a document that's not prepared by an attorney, but is prepared by your physician in consultation with you. Typically, a MOLST is prepared for people who are very elderly or very ill, and they want to be very specific about the types of invasive treatment they will receive towards the end of their illness or the end of their life. So the physician will go through those various things with you, things like dialysis or CPR or intubation, anything that's invasive to your body. Basically, this form allows you to say, yes, I would like this done to prolong my life, or no, I would not like this done. Please don't do it to me. So it's done with your physician because it does involve these discrete medical procedures that you need to understand before you say yes or no to them. And once you've signed that and your physician has signed it, that goes into your medical record and is a medical order. So it's different than the living will. That's just an expression of your wishes. The most is an order that will be carried out. And the final healthcare document, I'm sorry. This is talking about what happens if you don't have a healthcare proxy. So let's talk about that first. You want to have a healthcare proxy so you can choose who will make your healthcare decisions for you. You might think if you have a spouse or if you have a child that those people are automatically able to make your healthcare decisions for you. That's not the case legally. In practice, if you're sick in the hospital and you have a spouse, who's there every day with you, and the doctors can see you have a good relationship, they may, take direction from your spouse informally. But legally, that spouse has no more authority to give the doctor direction than anybody else. And if you're not able to give direction yourself, the law says you either have a healthcare proxy that names a healthcare agent that has that authority, or the court has to appoint a guardian for you to make those kinds of decisions. A guardianship is a long drawn out proceeding. It's very intrusive. There are hearings involved. It takes a long time. It's expensive in terms of legal fees. And it's definitely not a place you want to be or something you want to be going through if you are ill and you're needing healthcare decisions made for yourself. So the healthcare proxy is a really important document to allow us to avoid the guardianship and make sure, the person you choose is making your decisions for you. There's plenty of people who have, 3 or 4 kids, and everybody might have their own opinions about healthcare and how you should be cared for. But you might know that one of your children, has views that are similar to yours, or that would listen to your views over the others. And that's the child, you would want to choose as your healthcare agent. So having the ability to choose the decision maker is a really important thing. All right, here we come to the final healthcare document, which is the HIPAA authorization. This is just a permission slip to your doctor that basically says, I've listed on this document the people I'm authorizing you to share my medical information with. These are not decision makers, but they're people that can get information from the doctor. They can pick up the phone, call the doctor and say, my mother's in the hospital. I want to know what's going on with her. Can you give me an update? Otherwise, the doctor can't share that kind of information without your permission. So this is just a permission slip you'd sign in advance. So if that situation arises, your family members are going to be able to get the information they need. So before we go on to the documents, the post-death documents, let me just say that in terms of how you get these documents prepared, a lawyer would have to prepare a durable power of attorney for you. Healthcare proxy forms are available from your doctor, as well as the HIPAA authorization form. The healthcare proxy a lawyer may prepare for you will probably be more comprehensive and give your healthcare agent more powers than they would otherwise have. So I think that's an advantage, but in a pinch, these documents can be obtained from the doctor or even online. You want to make sure you get a Massachusetts healthcare proxy form if you're a Massachusetts resident. And if you are a resident of another state, make sure you're signing a healthcare proxy in the state where you live, because those forms are very state specific. All right, let's move on to what happens after you die. We want to make sure that your assets are going to go where you want them to go. So there are a couple of different documents you can create that will make sure that happens. The most basic one is a will, which is a document that says, any asset I own in my individual name at the time of my death, this is how I want it distributed, and this is to whom I want it distributed. Your will is not going to control assets you own jointly with somebody else, or assets that have a beneficiary on them, which will pay automatically to the beneficiary. but the will control any other type of asset that you own. The will is going to name somebody called the personal representative, who is in charge of carrying out the instructions in your will, identifying what assets you own, paying your debts, paying your taxes, and distributing what's left according to the will's instructions. We used to call them executors. You might be more familiar with that term, but now, since 2012, Massachusetts law changed to bring us more in conformity with other states. So now we refer to the executor as a personal representative. So when you create a will, think carefully about who you trust to carry out these instructions at your death, treat the beneficiaries fairly, communicate well with everybody, and make sure everybody knows what's going on, and is able to work well with an attorney who will help the personal representative, settle your affairs after death. If you don't have a will, the laws of Massachusetts will say what happens to your assets. Those laws can be complex, depending on your family situation, and depending on whether you have a spouse only, a spouse and children, whether the children are also children of your spouse, or whether you have a blended family. The rules are different based on the family situation. But without a will, you're really leaving your assets to the mercy of what the state legislature has decided is the best way to distribute assets under your particular family situation. So not always a great idea to just leave it up to what the law says. It's always a good idea to sit down with a lawyer, have a will done, to be very clear about what your wishes are and where you want things to go. Some people might choose to use a trust to distribute assets after their death. A trust is just an agreement between the person who creates the trust and somebody called the trustee, who's in charge of managing the assets that are owned by the trust for the benefit of the beneficiaries of the trust, who are also identified in the document. So if you're alive and well, you might create a trust that says that you are the trustee and you are the beneficiary while you're alive, so that any assets that are owned by the trust you can use and control and spend as you like. And after your death, that document might say, I name my child as trustee, and I name all of my children as beneficiaries, and my instructions are that the trustee should distribute the trust assets equally to my children as beneficiaries after my death. So you might say, wow, that sounds kind of like what a will would say. How is this different? And the reason it's different is that a trust can own assets in its name while you're alive. So rather than holding assets in your individual name, you can hold the assets in the name of a trust. And the advantages to that are that when you pass away, we will not have to go through a probate proceeding at the probate court to transfer title to those assets to your beneficiaries. The trust will automatically distribute the assets to the beneficiaries without the need for a probate proceeding. So trusts are used to save time, save money, and get things done more quickly and more efficiently after your death. Trusts are also important if you have young beneficiaries, minor children or grandchildren who you want to benefit, but who you might not want to receive the inheritance you leave them right away because they're too young to manage those assets. The trust can hold the assets for their benefit for some period of time until they're old enough or mature enough to manage things themselves. Certainly, if you have a disabled child or other person you would like to benefit, trusts are very important because if the disabled person is receiving any kind of public benefits like SSI or Social Security disability benefits, sometimes the receipt of assets can affect their ability to continue to receive those benefits. Mass health benefits are another example of that. So you want to make sure that money stays in trust for their benefit in such a way that it's not going to adversely impact their benefits when they receive the inheritance. Trusts can also be used for estate tax planning for married couples. If you have assets that are worth more than $1 million in Massachusetts, there will be an estate tax that's payable at the death of the second spouse. And that can often be reduced or eliminated if the right kind of trust is used during your lifetime to protect those assets. So that's a little bit about trust. That's a big topic, but that's an overview. So let's just review. If you're choosing the personal representative of your estate, which remember we used to call executors, or if you're choosing a trustee, you want to choose someone who's trustworthy, organized, a good communicator, responsible with money, not a procrastinator. You know, things need to get done in the world of trusts and estates. So you want someone who's going to move the process along, be responsive to the attorneys and the accountants who might be asking them for information, and ultimately get the assets distributed or into the trust account where they're going to be held for the beneficiaries. So you can consider a family member, you could name a friend. If you don't have any good candidates, a bank or a trust company or a professional trustee are all options. Here's the last document I want to talk about. This is a declaration of homestead. If you own a primary residence in Massachusetts, you should have a declaration of homestead. That's a document you file at the Registry of Deeds. You can obtain the form online, or an attorney can prepare it for you. You will need to fill it out with information about the deed to your house, and then bring it to the Registry of Deeds or mail it, and along with a check for $35, and they will record it. And once that document is recorded, it basically declares that this is your house, and it gives you protection of the equity in the house against a creditor who might get a judgment against you for whatever reason, and try and force a sale of the house to pay that judgment. What the homestead says is, hold on, creditor, you know, there's a homestead here, this house is protected, and if you sell this house, the first $250,000 of equity if you're under 62, or the first $500,000 of equity if you're over 62, belongs to the owner of the house, and you can't get anything unless there's more sale proceeds than that when this house is sold. So the homestead, you know, protects a good chunk of equity. Generally, it will dissuade anybody from trying to force a sale of the house because they may not be able to get anything. And if you have a spouse, those numbers are doubled. So it's a valuable protection. If you don't file a homestead, you have automatic protection of $125,000 of equity in the house. But you know, in our area, that's not a whole lot of equity to protect when our real estate is worth what it's generally worth in this area. So it's a good idea to file a homestead, declare a homestead, rather than allow the automatic protection to kick in. Okay, so some of you may say, I've been to Maria's seminars before, and she's told me to do these documents before, and I've already done them. Hooray for me. And that's excellent. And if you have these documents, you're definitely ahead of the game. But you need to make sure that they're still up to date and they still accurately reflect what your wishes are. So review them. You know, as much as it's not pleasant to read your will, you don't need to do it every week, but you know, once every year at least, you know, pull those documents off the shelf, dust them off, and read through them and make sure that they still are what you want, you know, in terms of the people you've named in the documents, you know, who's your personal representative, who's in your power of attorney, who's making your healthcare decisions. Are those people still alive? Are they still, you know, close to you? Do you still trust them? And do you still want them doing those things? And then look at how the documents are distributing your assets and consider whether that's still the way you want it to be. You know, as much as we'd like to do these documents once and forget about them, our lives change, things change. People come in and out of our lives. So we need to make sure the documents are still current and up to date because we never know when they're going to be needed. So, and if even better, you might want to call the attorney who prepared the documents and ask them, is there anything I should know about updating my documents? Has the law changed in any way that would make these documents, you know, stale and in need of updating? So, and your lawyer can help you out with that. So make sure you review things, even if you have them, and make sure everything is up to date. If you have more questions or you want more information about any of these things, I invite you to go to our firm's website, which is here, ssbllc.com. There are 4 lawyers in our firm. We write articles every month about these topics, and we have them posted on our website for anybody to read. And you can search for any particular topic you want or just browse through things, but there's a lot of information there. So I encourage you to educate yourself about the particular documents. And if you don't have these documents or you need to update them, I'm certainly happy to help you, but contact any qualified estate planning attorney in your area to work with you on getting a plan in place. The most important thing is getting these documents done, however you get them done. And let me just say, I do not encourage people to use online forms for these documents. I have said you can get the form for the healthcare proxy online, you can get a Homestead form online. Those documents are meant to be user-friendly for consumers. But any of these other legal documents is not something you should attempt yourself. You can often create more issues than you solve unknowingly, because you're not a lawyer, you don't draft these documents every day. So I would encourage you to work with a lawyer and get these done the right way, so that your family will be able to do what they need to do when the time comes.
As always, Maria, you are amazing. And I always learn just a little bit of more each time I listen to you, like pearls of wisdom. But I do have a few questions. So,
Okay.
If you're in Florida, because I asked around and asked some seniors what were some of the questions they'd like to ask you. If you're in Florida 6 months of the year, does your health proxy follow you? How do you, what happens if you get sick when you're out of state?
Yeah, that's a really good question. So, in general, you should have your estate plan documents done in the state that's your primary residence. And even if you're in Florida 6 months a year, you might be a Florida resident, you might be a Massachusetts resident, but you're a resident of one of those states. So your main estate plan should be done in that state. And any documents that are done in one state are valid in any other state. There's no, your documents don't become invalid just because you happen to be in Florida. If you get sick in Florida, they should honor your Massachusetts healthcare proxy.
Good.
That being said, I still encourage people, if you spend a significant amount of time in Florida, it would not hurt to go to a Florida attorney and have a Florida healthcare proxy done, for that time you're in Florida, just because that document is more familiar to the Florida doctors and hospitals and might be a little different or have some different provisions than we have up here in Massachusetts. So what do they call it? Belt and suspenders approach. Do a healthcare proxy in both states, but if you don't want to do that, it's fine. Just make sure you have a copy of your healthcare proxy with you when you travel. And we encourage people now to save them on their phones.
Very good idea. Yeah.
Yeah, our smartphones. You can have an app where you can save documents and scan your healthcare proxy in and save a copy on your phone. So it's always there. And also give it to your family to do the same thing.
That's actually a great idea.
Hmm.
Okay, so this is another question I got. What would be for instance, I always suggest, I love working with you, and I know you are very good about stuff, but what is the typical cost to put these important documents together with a lawyer? Just, and I know there's a wide range, but just typically, what should people anticipate?
I think they should anticipate, for basic documents for a single person, probably $1,500 to $2,000 in this particular area.
Okay.
For a married couple, more than that. If you're going to do a trust, it's probably another $1,000 on top of that. These documents aren't inexpensive, but they'll be done right.
Absolutely. And that's what we keep telling people. Do it once and do it right.
Right.
You don't have to worry about it. Spend the money up front so later on it doesn't come back.
Yeah, that's the thing. You do it right now so that your family doesn't have to clean up the mess afterwards. Or you don't have to go through a guardianship or something that's going to cost a lot of money and will affect you while you're still here.
Okay. And finally, my last question is, we are working with you on this. If you don't have anyone that you trust to be your power attorney or your health proxy, we're actually working on that. We don't talk about it, but what is the best way to move forward?
Well, I think you need to speak to an estate planning attorney about that and let them talk you through the options.
Okay.
There are some care managers and social workers out there that will serve as healthcare agent for people who don't have family members who are able to do that. There are some lawyers or other professionals that will serve as power of attorney for people who don't have someone they trust to do that for them. But you have to, you have to be very careful when you're picking those people, and be comfortable, talk to them and be comfortable that they understand your wishes and will have your best interests at heart. So you can't just name anybody. You got to be particular about who you name. And there are people who can help you out if you don't have anyone good to name. Try not to let that stop you from doing the documents altogether, because it's a problem that can be solved. It's not easy, but it can be solved.
As always, Maria, you are unbelievable. I'm so grateful for this partnership. I really mean that from my heart, in my head. To all my seniors out there, please stay safe. I know you're feeling isolated, especially through the holidays. Please call us if we can do anything for you. Please read. We just sent out our December newsletter. Please make sure you read it, because we've got a lot going on. And don't forget, social distance and wear your mask. No matter where you go, please remember to do that. Again, we are very grateful for you, Maria. And thank you for your time and your expertise. And hopefully we will get through this pandemic together. And we will see you maybe in the spring.
Yes, hopefully.
Take
Thank you
care.
so much, Dina.
Yep. Take care, everyone.
Okay.
Bye.
Bye.